just preparing the live stream at the moment. This meeting is now going to be recorded. The meeting is now recorded.
Thank you. Good afternoon, everybody, and welcome to this first virtual meeting of Boston Borough Council's Licensing Committee. My name is Councillor Jonathan Noble, and I'm the chairman of this committee, and Councillor Frank Pickett is my chairman. As with all virtual meetings, and to allow public recognition of who's in attendance, we will now take a roll call of attendees. So, Jeanette, over to you, please.
Thank you, Chairman. If attendees could verbally acknowledge they are present, please. Councillor Tom Ashton.
Present.
Councillor Alison Austin.
Present.
Councillor Alan Bell.
Present.
Councillor Deborah Evans.
Present.
Councillor Frank Pickett. Councillor Pickett, I think you're on mute. I can see you here though. Hello. Thank you. Councillor Colin Woodcock.
Present.
Councillor Stephen Woodliff.
Present.
Fiona White, Licensing and Land Charges Manager.
Present.
Myself, Senior Democratic Services Officer, and of course, Councillor Noble, the Chairman.
Thank you, Jeanette. I'll just explain a few rules. Unless you're joining us via your mobile phone, could you please ensure your phone is switched off or set to silent, and turn your microphone to mute when not speaking to avoid unnecessary background noise. Could members please indicate via the raised hand facility if they wish to speak, and they'll be invited to address the meeting, or you'll be invited to address the meeting in the order that you register to use that facility. I'm now going to move to part one of the agenda. No, I beg, no, I'm not quite. Hang on. Sorry. First of all, have we received any apologies for absence, Jeanette?
Yes, Chairman, we've received apologies from Councillors George Corner, Anton Danny and Judith Skinner.
Thank you. Now, I'm about to sign the minutes of the last meeting that was held on the 6th of November 2018. Only one member was present who was actually attending the meeting, and that's you, Councillor Woodliff. And I don't know if you have any brief comments to make. It was all about the revision of the Statement of Principles with reference to the Gambling Act 2005. But do you have any comments on that very briefly, Councillor Woodliff?
No, Chairman. I'm
Okay.
afraid actually I have difficulty remembering it. Actually, I'm afraid such a long time ago.
It was 6th November 2018.
So, but
Okay.
no, I have no comments about it. It's
Thank you.
right?
In which case, do I have a proposer?
Have to be me, won't it?
You'll propose. Thank you. Thank you very much, Councillor. Do we have a seconder?
Can it be me as well? No.
No, I don't think so, Councillor Woodley. I think we need someone else to second.
Okay.
Yes, Chairman.
Thank you, Councillor. Oh, Councillor Ashton. Yes, Councillor Ashton, please.
Thank you, Mr. Chairman. Taking it upon Councillor Woodliff's good word that the minutes are accurate, being the only person here that were present then, I'm happy to second.
Thank you very much, Councillor Ashton. Jeanette, I think we now need to move to a vote, don't we?
That's right, Chairman.
Please,
Simply to confirm that the committee is receiving the minutes.
Yes.
Councillor Tom Ashton.
Agreed.
Councillor Alison Austin.
Agreed. I was going to say, well, I was probably the only other person in the room who was on this council at that stage, but no, I think some more were in 2018. Okay, yes, agreed.
Thank you. Councillor Alan Bell.
Agreed.
Councillor Deborah Evans.
Agreed.
Councillor Jonathan Noble, Chairman.
Agreed.
Councillor Frank Pickett.
Agreed.
Councillor Colin Woodcock.
Agreed.
Councillor Stephen Woodliff.
Agreed.
That's unanimous. Thank you, Chairman.
Thank you. Obviously, I will now sign and confirm them later by email. Right, let's move on. Have we received any declarations of interest in respect of any item on this agenda? Do we have any declarations of interest from fellow councillors? That seems to be no, in which case we shall proceed. We have to receive any written questions from members of the public. Jeanette, have we had any written questions?
No, Chairman, there are none.
Thank you. In that case, that concludes the preliminary items. We're now going to move to part 2 of the agenda. There's only one item of business today. It's the draft statement of licensing policy. It appears on page 3 of your agenda. And of course, our key aim is to review and amend this draft statement of licensing policy. Before I go to Mrs. White to present the report, can I just ask you something, please, Mrs. White? This is referring to the kind of preamble or introductory stuff on page 7, if members look at that, and it's point 3.3, and it says this: following approval of the final draft statement of licensing policy by the licensing committee, a recommendation will be made to that committee that the policy be referred to the full council for adoption. Should not that read, a recommendation will be made by this committee to full council?
Yes, I think it's just the way I've worded it in what I mean. It's I'm going to make a recommendation to you to then make a recommendation to full council. But it could be, yes, yeah, I'm quite happy to have that amended for wording that suits you, Councillor Noble, Chairman.
Okay, in which case, now we're going to you, Mrs. White, please, if you'd kindly present your report, and following that, obviously, we'll open the matter to debate. Thank you, Mrs. White.
Thank you, Chairman. If you agree, Chairman, what I'll do is I'll present the report and, as discussed with you, go through some of the more salient amendments, and then are you happy for questions at the end or as we go?
Yes, I think that's a perfect way to proceed. Thank you.
Thank you, Chairman. The Licensing Act 2003 requires a licensing authority to carry out its functions under the legislation with a view to promoting the licensing objectives. Those licensing objectives are the prevention of crime and disorder, the prevention of public nuisance, public safety, and the protection of children from harm. Under the Act, the licensing authority must, in respect of every 5-year period, determine its policy regarding the exercise of its licensing functions and publish a statement. That was last done in 2015. The draft statement of licensing policy is attached to Appendix A, and you'll note that some of that is in red, and they are the proposed changes to the statement of licensing policy. You requested to review that and then make any amendments that you think are appropriate today. Following that, we will have our final initial draft of the statement of licensing policy ready for consultation. There are some statutory consultees, being the responsible authorities, and also we are required to consult with such people as considered to be representative of holders of licensed premises, holders of club premises certificates, representatives of personal license holders, and also other such persons considered to be representative of business and residents in the area. So it's quite an extensive consultation that we will undertake. Following that, we're required to give appropriate weight to the views of all the consultees before determining a final draft statement. So what we normally do, and I propose to do this time, is once we have the results of all of the consultation, this will be brought back in front of this committee for you to consider those amendments and integrate them into the final draft as you see fit, or not, if you don't think it's appropriate. And then as we get down to paragraph 3.3, I will recommend in that subsequent report to you that a recommendation is then made for it to go to full council for adoption, after which will be published. And the timetable for that is for it to go to full council in November. So we'll go out to consultation shortly after this, back to this committee in early November, and then to the full council meeting also in November. So turning to the actual statement of policy itself, I will go through the major changes. The first one being on page 13, we've added an executive summary, which we haven't previously had. And this just briefly gives an overview of the Act and what the policy is about. Then turning please to page 21, the next changes. In our licensing policy, we can't tell people what they've got to put in their operating schedules, but we can give examples of measures that we as the licensing authority would like to encourage applicants to consider and address. And at the top of page 21, I've added measures to tackle street drinking, including not selling single cans or bottles of beer, lager or cider, not selling super strength, which is the ABV above 6.5 of beer, lager and cider, and attaching waterproof labels with printed shop names and addresses to cans and bottles of beer, lager and cider. The reason I've put that into the list of suggested measures people can take is this arises quite frequently at licensing hearings, particularly with the single cans. And by having this in our policy, it just adds a little bit more weight when you want to add it as a condition on a license, if the applicant hasn't already chosen to do so, or if we're at a review, it adds a bit more weight to a decision that you may wish to add a condition about this. And therefore, particularly should we have an appeal, what you've done is you've got the weight of our policy behind you when making a decision to add a condition about that. So this is in an effort to tackle the concerns people have about street drinking and the selling of single cans. I think it just makes it that little bit easier for you to add a condition and have the policy behind you to do so. At the foot of page 21, I've always also added in under risk assessments, and that would have previously included fire risk assessments. I've added the words including fire risk assessments. The reason I've added for that is it's become quite apparent at hearings that licensees aren't aware of the legal requirement to carry out a fire risk assessment. And we have indeed actually had one case where we had quite serious concerns about the lack of knowledge on fire. So whilst it's not a requirement of the Licensing Act, and we do have to be careful not to duplicate legislation, this is effectively a guidance document as well. So if we put it in there to include fire risk assessments, we then again have the ability to, when people say, I didn't know I needed to do a fire risk assessment, or they're not aware, it's there in our policy so that we have drawn it to their attention. The next sort of larger amendment is at page 26. This is simply a change in the legislation that came in quite a long time ago, but it's now changed. So it's the responsibility of the applicant to send a copy of their application and other relevant documentation to each responsible authority, unless the application has been properly made electronically, in which case it is the responsible authority. Sorry, it is the responsible of the licensing authority to circulate it. That's just a minor amendment because once electronic applications came in, the onus falls to us to circulate that. So we've just amended the wording slightly. The next larger change is at page 31, and where we've added, this is about reviews of licensed premises, and we've added in, however, the licensing authority does not, as a general rule, intend to act as responsible authority on behalf of other parties, for example, local residents, local councils and community groups. Such parties can make relevant representations in their own right, and it is reasonable to expect them to make representations themselves where they are reasonably able to do so. This is because we've not had this in previously, although the licensing authority can act as a responsible authority, but it's not an ideal situation for us to be doing that. It's far more preferable for an independent body like the police or environmental health to be reviewing a license rather than us reviewing it when we issued it in the first place. So that's just drawing a line in the sand saying where required we'll do it, but it won't be the first option that we review a license or make a representation. Below that, we've got a section on cumulative impact, which has the wording has changed quite significantly. The main reason for the changes in this is that the wording in the section 182 guidance, which you will all know is the statutory guidance under the Act, has changed. Partly that's because cumulative impact is now included in the Act. It doesn't change anything. It's just the Act was silent before and it was only contained in the guidance, and now it's in the Act itself. Cumulative impact is mentioned in the Act itself. It doesn't change the burden of evidence required for a cumulative impact policy. It doesn't change the circumstances in which you can have a cumulative impact policy. It's just simply mentioned in the Act now. And because the Section 182 guidance has changed, we've made some amendments to reflect those changes. Just going through them briefly. Sorry, bear with me. At page 31, it does say that it's now included in the Act. There is a paragraph that's been deleted because the wording has changed slightly, so that has been deleted. We've added in that evidence from parish councillors would be considered. That previously wasn't in the Section 182 guidance, so that's been added in to reflect the Section 182 guidance. At the top of page 33, the list at the top of page 33 is a direct lift from the Section 182 guidance. Therefore, it's been amended to reflect what the guidance says. Also on page 33, there's mention of early morning restriction orders. The wording of that has been amended slightly just to improve it. It reflects the 182 guidance, and it also reflects what other local authorities in Lincolnshire have got in theirs to try and be consistent. I've appraised their their licensing statements, as I have all the way through the document. I've looked at other both national and Lincolnshire documents just to try and aid some consistency. At the top of page 34, you'll see there's a list at paragraph 15.5. Again, this is a direct lift. It just is in there. It's been added just to give additional information, additional guidance, and a little bit more information for people reading our policy. The next significant change is at page 40, I've removed challenge 21. I'm waiting to see whether I'm challenged this out when we go out to consultation. We may have to replace it. We used to advocate people having challenge 21 and challenge 25. We tend to go with the challenge 25. It's more robust to challenge people that look under the age of 25 than it is to challenge people that look under the age of 21. If the committee are in agreement, because it is the standard we tend to use on conditions, by keeping the challenge 21 in there, it's diluting the standard we're setting. People could challenge us back on our own policy. We could say, oh, we advocate challenge 25, and they could say, well, in your policy, it says challenge 21 and challenge 25. So we may have to renege on that if we get a lot of complaints, but if the committee are happy, let's see how it goes, because I do think the challenge 25, for members that have sat on hearings, I would hopefully would agree that it is more robust and it is the preferable option. There's a lot of people that may be under 18 that might look 21, but I doubt they'll look 25. Also on that page, you'll see there's a whole new section on suspension for non-payment of annual fees. That's because since we last revised our policy, the Act has been amended. What used to happen is if someone didn't pay their annual fee, the only way we could recoup that money would be by civil action and going to court to get an order for them to pay it. We couldn't sort of do anything that would encourage them to pay it, shall I say. Now we can suspend licenses for non-payment of the annual fee, and we do suspend them, and that seems to encourage people to pay. So we now have a paragraph or two in there which reflect the change in legislation. Similarly, on the next page, page 41, you will see that there is a section on the Immigration Act and entitlement to work. Again, that is a new requirement since we last revised our policy. That came in 2017, and we're now required to do right to work checks on applicants for personal licenses and applicants for premises licenses prior to us granting a license. So that's why there's the addition of that. At the foot of this page, we've added a paragraph about making minor amendments. When there's small changes in legislation, our policy can become out of date. For example, they changed the number of temporary event notices or the number of temporary event notice days you could have a year. And we were in a position where we can't change the policy without doing a full review. So that paragraph at the foot of page 41 is to say that we can keep it under, it's essential to keep the policy under regular review. And where there are minor changes, for example, that reflect legislation, we can simply then change it without, we don't, it doesn't make a lot of sense to come to a committee to change a policy when there's a change in legislation, when you wouldn't have any discretion anyway. And finally, what we've added on the very last page, at page 46, is a version control, so as that if we do make any minor amendments, we can complete the version control boxes, and therefore the public and you committee yourselves will be able to see any changes. Of course, if we did make any changes under delegated power because of legislation, we would notify you as committee members that we've made those changes. We would keep you informed. Thank you, Chairman. If there's any questions, please.
Yeah, thank you, Ms. White. That's a very clear presentation of the proposed changes, and I thought you'd highlighted all the salient points. So thank you very much for that. We're now going to open the matter to debate. Does anybody wish to speak? Yes, the first hand visible is Councillor Austin, followed by Councillor Woodcock. So, Councillor Austin, your observation, criticism, or question, please now.
Councillor Austin, you are muted.
Sorry. Right. First of all, Chairman or Fiona, do you want me to sort of go right through with everything I've got little questions on? Because otherwise, you know, I can say, well, page 31, and then somebody else wants 31, or do I just go right through all my things first?
I think you go through your list, and anything that other people have in common, then the matters have kind of been dealt with and doesn't need to be spoken about by other members at any great length. So off you go, please, Councillor Austin.
Right. Well, some are just observations.
Mm-hmm.
Yes, on page 31, when you talk about cumulative impact, that is very emotive, isn't it, with a lot of people, especially when it's items from alcohol, betting, all these things, especially when it's concentrated in the marketplace or the town centre. So I'm glad you see, I think, adequate measures there. Another, again, emotive one, I think, possibly is early morning, when there are shops selling alcohol early in the morning, because they're probably then cans and so on are going to be picked up by people going to work. Is that an issue where we have problems? Because often, of course, people are going to work before 6. So that is adequately covered, is it? It's not just these early morning restrictions don't presumably apply just to activities.
Sorry, Councillor Austin, which particular page are you referring to when you're making these comments?
Page 33 in general, 15.2,
Mm-hmm.
when we're probably, is that really aimed more at the sort of late night economy where, you know, clubs and things are still open, or is that also aimed at small corner shops and that sort of thing? So
it's aimed at the late night economy, and I have to say there are very few, if any, early morning restriction orders nationally because they get challenged. If there are areas of high disorder, then an early morning restriction or early morning restriction order may be appropriate. But what you have to bear in mind is it then will apply to all the premises in the area in which you've set it. So effectively, if you said we're going to put one on the town centre, everywhere in the town centre would have to shut at midnight, and that's why they're not popular. Where if we have individual premises that are causing problems, then without you can tackle them individually by way of review of a licence, or not granting it in the first place if you don't think it's appropriate. So they are really designed for areas where significant disorder is occurring, and I have to say they are very few and far between because of the challenges that come with them, stifling the nighttime economy by requiring premises to close earlier.
Right. Chairman, may I continue?
Please, yes, that's what we said. Yes, if you go through your list.
At the top of page 33, what is, I've not heard of Best Bar None. What's that?
Best Bar None is a scheme that town centres or they are run by a group of people. For example, it's a partnership where it's like the police, fire, environmental health, licensing, and it's an award scheme where if a pub meets a particularly high standard, it can get a badge for meeting the Best Bar None standards.
Ah, right, thank you. And on that same set of bullet points, I note that we have now got in red provision of public conveniences open late at night. Are we satisfied in Boston that we do have sufficient public conveniences open late at night? Who would be responsible for those?
The wording from this is a direct lift from the section 182 guidance. So we're not specifically saying this is our policy. They're saying these are a number of mechanisms that can be used. They are suggestions of things that can be used for preventing cumulative impact, and that the provision of public conveniences, we're not saying in this policy that we have that. It's a direct lift from the guidance.
Right. I've two more comments, quite quick ones. Yes, challenge 25, that is certainly the one to go for. I've no doubt about that. And my final comment relates to the Immigration Act on page 41, and I think I was sort of hovering on 31.5 because with a view to preventing illegal working in premises license for the sale of alcohol and or late night refreshment, I would like to think that one includes any form of working going on on that premises if it has is being licensed. Is being licensed, because of course one of the things that we do have to always keep an eye on is what's known as modern day slavery, isn't it? And that could just be people cleaning up, but equally it could be people either legally or illegally in the sex trade. And I don't quite know whether this somehow could catch everything if necessary, or anything if necessary.
Thank you, Councillor.
My comments.
Thank you very much, Councillor. I think the phrase that there, the last sentence about preventing illegal working, does cover it. And just for your information, in case you didn't know, we removed the licence from the Rose of Bengal in West Street not very many days ago because they were employing illegal workers. Right, I'm going to go, thank you for that, Councillor Austin. I'm going to go to Councillor Woodliff, whose hand is up. Councillor Woodliff, can we have your questions or observations or criticism, please?
Thank you, Chairman. Thank you very much. First one's a minor one. Page 31 on this list, it's section 13.4, and it says, however, the licensing authority does not, as general rule, there's a bracket missing. I know what mathematicians like for brackets, don't you, Jonathan?
Oh, thank you, Councillor.
And the spelling of council as well. You're at it, sorry.
Bod math, brackets order. Yeah.
Yeah, Councillor Woodliff, I quite agree. And also this council's is misspelt.
Yes.
It should have two L's in it. Okay, sorry to interrupt.
Thank you.
That's fine. That's the minor bit. The other bit actually is page 27, and it's 510. The new line there, 510 on 510. The licensing authority acknowledges that the views of the vocal minorities should not be allowed to predominate over the general interests of the community. The question really is, how are you going to determine the general interests of the community? That's the question, isn't it? I mean, vocal minorities, you know, if there's 3 people shouting about something, that's fairly clear, isn't it? But how do you determine what the general interest of the community is? That's a question. isn't it?
Quite, yeah, quite
I would
right,
say
Councillor. That's an
each
opinion.
case on its own merits, Chairman. This is from the Section 182 guidance. Each case on its own merits, but there are, you know, where we have to look at what, from each application or each review, what benefit would come from revoking the licence, or what benefit would come from not revoking the licence, what benefit would come from granting a licence to as opposed to not granting it, against balancing that against the number of people that are objecting. So, for example, if I can use an example, if I may, if we had a big party in Central Park for 10,000 people and we got 20 objections, we might say that the vocal minority of 20 people objecting can't predominate over the general interest of the community, because it's a massive event for lots of people. However, if it's a shop on a small street and we only get 5 objections, that might seem very valid, and that, you know, and they you know, we may take those into account, even though there's a much smaller amount of people. So I think the general interest of the community is really based on what the event is, and each one on its own merits. We don't know what that is without viewing the application and weighing it up.
Thank you. Just we're on that sentence that Councillor Woodliff has highlighted. Do we need the in, because it talks about, let me read it again, the vocal minorities, as if it's the finite list. I mean, surely it's not a finite list, so I don't think you need the word the. I think you just want vocal minorities.
Removed.
Certain
Quite right.
It's not necessarily the case. Councillor Woodliff, sorry, back to you.
Oh, absolutely right, Chairman. Absolutely right.
Do you have anything
yeah,
else you want to say? Sorry, Councillor Wood, anything else you want to say? You know, any other...
Yes, there is actually.
Yes.
And it's not actually to do with the changes. It's to do with actually on page 37,
Yes.
which is about petrol stations, garages, and other similar premises. And it defines a premises, a garage, if it maintains motor vehicles. If my neighbour is maintaining motor vehicles for his business, does that mean he can set up a shop to sell alcohol, and which is outside Section 176 of the Act? I'm not quite sure what that really means.
No. What this is about is that before, it's a little bit historic. Many years ago, before the Licensing Act came in, it was illegal to sell alcohol in petrol stations and garages where vehicles were maintained. When the Act changed, it became a little bit more flexible. So what it's saying is that if we get an application from a business, we will consider it. Now, if your neighbour who's mending his cars and has a business there puts in a licence for the sale of alcohol, then yes, we will consider it. I would suggest it probably won't be granted. It probably won't have planning permission, but whereas under the previous legislation, you couldn't consider it. But what the Act now says is you have to balance up what the bear with me, primary activity is. Sorry, I couldn't think of the phrase. So you'd have to look at the primary activity. So where petrol stations in town are more like little supermarkets now, and that isn't their primary activity, we would probably agree to grant a licence. If it was somebody mainly selling or maintaining cars, then that would be their primary activity, and we wouldn't probably grant a licence for a fridge in the corner selling alcohol.
Fine. I'm just, the reason why I asked that question, because you know there's a garage on Sleaford Road, isn't it, that sells alcohol, has a 24-hour licence, I think, doesn't it?
It does indeed, yes.
You know, and that seems out of line with all the other restrictions that we place on all the shops in the town, about corner shops where you can only sell alcohol from, say, 6 in the morning to midnight, and we get quite uptight about it. But if you have a garage that's selling alcohol 24 hours a day, 7 days a week, rather undermines all our policies, doesn't it, really, or our position?
Would you like to comment on that, Mrs. White?
Well, each one, I mean, I don't think this is, maybe, if you don't mind me saying, Chairman, the forum for discussing individual premises.
Yes, well, let's take it away from Seaford Road and just say that in another town.
But generically, yes, a garage, 24 hours.
Yes.
Generically, the application was made, there was no objections. There's never been cause to review it because there's never been any complaints. So each one on its own merits. A premises that had a 24-hour license, for example, a garage that hasn't been objected to, the licensing authority has no choice other than to grant the license, and there's been no complaints about it, so no grounds to revoke it.
No, I fully accept that. It's a well-run garage, and used to be in my ward, of course, so it was a well-run garage. There were no complaints, I'm sure, but it does seem to just undermine the kind of the method we go about when we look at shops in the town, not so far away, and we perhaps place restrictions on that. Then up the road, we've got someone who has no restrictions. It seems to be an unfair playing field, doesn't it, in a way?
Well, there's some of the large supermarkets have 24-hour licenses, and again, they haven't caused us a problem. I think the problem is with some premises open late at night, its location, and people can leave the town centre after leaving pubs and clubs, and then purchase alcohol when there is a likelihood that they may already be intoxicated, and of course it's an offence to sell to somebody who is drunk. Somebody attending a petrol station, putting some petrol in the car in the early hours of the morning, and then buying a bottle of wine to take home with them are hopefully not going to be intoxicated. So it is quite a different type of business.
I understand.
But if it caused problems, of course, it could be reviewed and the licence could be revoked.
Yes, I said, I mean, obviously we do have a problem with people drinking and driving, a bit less these days than perhaps in the past, but it still is an issue, isn't it? However, anyway, I accept your explanation.
Thank you, Councillor Woodliffe. We do recognise the Licensing Act is a permissive act. Right, I'm going to move on to Councillor Evans, whose hand is up. Councillor Evans, your question, please, or observation.
Well, I was going to say to Councillor Woodliffe that I have no problem with the garage. I think people are arriving in cars, and I think it's no different than Astor up the road, and they're not sort of already drunk and making lots of noise. So I don't see a problem really with that. I think I'm really happy with this. I think it covers everything. I think it's quite a thorough report, and Councillor Austin covered the questions that I would have asked. So I'm very happy with this. Thank you.
Thank you very much, Councillor Evans. We're going to move to Councillor Woodcock, whose hand is up. Councillor Woodcock, your question, please, or observation.
And it's 4.2.
Sorry, could you repeat that, Councillor? We heard not the page reference. Could you repeat, please?
Councillor Woodcock, you're on mute.
All right, I'm back. Right, sorry about that. I thought I'd unmuted myself before. However, anyway, page 21, public safety, 4.2.3, regarding suggested occupancy figures. Can you just expand upon that, please, as why it's suggested and not occupancy figures allowed?
I would imagine because I'll go to Mrs. White in a minute. I presume because the police take a view on the numbers that may or may not be appropriate for a particular venue or entertainment. But Mrs. White, would you elaborate, please?
Yeah, there's no requirement in law to set an occupancy figure. And therefore, if we were to say occupancy figures full stop, then we would be suggesting that license holders undertake to do something that goes over and above what we can require them to do legislatively. Whereas they can look at their fire risk assessment and come up with their own occupancy figure. There's no legal requirement for it.
Does that mean then that they have to go along with their risk assessment because let me just a hypothetical question, just like the garage was. Take a place that has 2 stories and it can allow 200 people in. And if that was spread out over the 2 stories, I can understand that. But there is a hypothetical place in not too far away that it's like that. It's spread out over 2 stories. And when a disco goes on, probably 180 of 200 cram into the upstairs area, and it is blatantly unsafe. It's so you can hardly move about. And and I ended up in there on a going away party, and I was just amazed that they could do that, to allow so people so crammed together. It was horrendously unsafe.
I'm more than happy, Chairman, that we take the word suggested out, particularly in light of the actual lead up to that. Says, depending on the individual style and characteristics of the premises or the events, the following issues may be of relevance. Yes. So I'm perfectly happy we amend it to occupancy figures.
As am I, and if any councillors aren't happy with that omission of suggested, please indicate by the hand now, or with the hand now. Everybody seems content with that alteration and the omission of suggested.
Done.
Thank you very much. Any other comments, please, Councillor Woodcock?
No, Mr. Chairman.
Thank you very much. There are no other hands up. Some of the points I'd want to raise have been covered. I'm going to go to page 29, and I have a question. Yes, it relates to 10.3 on page 29. It's just, really the last sentence. I'll read it out. Where an application for a personal license reveals a disclosable conviction for a relevant offence under the Act, the licensing authority acknowledges, new change, that the police carry out full and proper inquiries, skip the brackets, so as to provide evidence as to the reasons the crime prevention objective will be undermined by the grant of the licence, before exercising its discretion to make an objection. Do we really need those last few words? Is it not self-evident, before exercising its discretion to make an objection? Don't we take it for granted the police will do that?
Just bear with me while I read it.
Okay, thank you.
Where an application person. Yes, yeah, quite. So from the word before onwards.
I've already gone past this.
Before exercising its discretion to make an objection.
The last part, yes. Before exercising its discretion to make an objection. Isn't it obvious? So we don't really need those words in.
Fine, done.
Thank you. Next point, I'm very aware of members' time. We're going to page 34. Right, now, on the previous page, we talked about MRO's early morning restriction orders, and we learned that it's a decision of full council is involved. This is on 15.6, before the licensing committee determines to recommend that full council makes a proposed MRO. I want to juxtapose that with the late night levy and LNL on point 16. I want to know, please, Mrs. White, is that a decision of the licensing committee, or will it be a decision of full council? Because it does not stipulate and it does not make clear.
I would have to go back and check. I would suggest it's a decision of full council. I'd be very surprised if it isn't. Right. I can check that and I can make an appropriate amendment.
Please, if you would. Thank you very much.
It will be full council, but I can't categorically say it is. So I will check it and amend as appropriate. Right.
I did have a note on page 36 about payment licenses, but we've talked about very well in full council last night. So I'm going to pass on that. I'm going to go to page 44. And we've got a list here. And this is under the delegation of functions. I want to draw your attention to about 6 or 7 squares down. We've got, it's about tens. And it says determination of a police or environmental health representation to a temporary event notice. Is there no scope for representation to be made by an interested individual or a member of the public? Because I would thought that would happen in some cases.
No, Chairman. in the law, only the police or environmental health can make a representation. But if I may just add, Chairman, while we're here,
Yes,
if it's okay and the committee agree, at the top of those columns, it says Head of Regulatory Services.
yes.
That title, as of the last week or so, has changed. So subject to the committee agreeing, can I have authority to change that to the now correct job title of Assistant Director of Regulation, I think it is.
Okay. I'm sure members are happy with that. If not, they will indicate with the hand. So Assistant Director of Regulations, did you say?
I think that's what the new post is called. Yes, I've just noticed it. It's certainly Assistant Director. I think it's of Regulation. It's
Right.
Christian Allen, anyway.
Mr. Allen, yes, he's changed roles, hasn't he?
Yeah.
Yes. Okay, thank you. Just again on page 45, the second square down, we've got responsible authorities submitting a representation or applying for review of a premises license or club premises certificate. Is there no role there for the licensing subcommittee? Because it said head of service responsible for the area of concern.
This is where the responsible authority, where the licensing authority is submitting a representation or applying for review. So that's the officer side of it.
Yes.
Then it's delegated the head of service. You, of course, as an elected member, can apply for a review in your own right, but you'd be applying as an elected member. You wouldn't be applying as the licensing authority.
Thank you. Okay, we don't seem to have any more hands up. I have no further questions or comments to make. I'm just going to ask members again, is there anything more you wish, because obviously our key recommendation is on page 3, that we review and amend the draft statement of policy. We have done that. Is everybody content with what has been said and what has been done? If not, could you please indicate by a show of the hand? Right, in that case, there were no show of hands. We now have a proposal to approve the draft statement of a licensing policy for consultation as we've amended it. Can I have a proposer, please? Councillor Woodcock, thank you very much. Well, you please speak first, then it's Councillor Ashton. Yes, Councillor Woodcock?
Yes, I'm very happy to back that.
Thank you very much.
Yeah.
Councillor Ashton?
Happy to second, Mr. Chairman.
Thank you very much, Councillor Ashton. Right, it's been proposed and seconded. Jeanette, can we please take the vote?
Thank you, Chairman. If you could say for or against or abstention. Councillor Tom Ashton.
For.
Councillor Alison Austin.
For.
Councillor Alan Bell.
For.
Councillor Deborah Evans.
For.
Chairman, yourself.
For.
Councillor Frank Pickett.
For.
Councillor Colin Woodcock.
For.
Councillor Stephen Woodliff.
For.
That's unanimously carried, Chairman. Thank you.
Good. Thank you, Jeanette. Thank you, everybody. That concludes our business. Just before I close the meeting, a big thank you, please, to Mrs. White for a very clear presentation of her report. And I think we've made the necessary changes that had to be made. And so I just wish you all, it's a beautiful sunny day. Thank you all very much for your attendance and really enjoy the rest of your day. Thank you, everybody, and goodbye.
Thank you, Chairman.
Chairman.
Bye.
Councillor Woodley.
Bye, everyone.
Bye, Councillor Pickett. Goodbye, Councillor Woodcock. I can see you.
Okay.
For the benefit of the public viewers, the meeting will now be stopped.